Thank you very much. Mr. Klein, let's start with you. In your prepared testimony, you referred to a recommendation made by PCLOB in your 2014 report, which was really good, by the way. And we, in response to that, we added language to the USA Freedom Act, a section requiring a FISA court to select amicus curiae, to be able to present arguments in certain cases where there's an order that's necessarily going to involve a novel or significant interpretation of the law, as determined by the court, of course. In your view, does the FISA court utilize this provision as often as it should?
That was a recommendation made by my predecessors, but I strongly agree with it. I think it's absolutely essential to increasing the public credibility of the court, which after all is staffed by real Article III federal district court judges, and so it should be credible, but of course we also have the adversarial process in our normal courts, and we all assume, and I think we all agree, that that improves the quality of decision making. If you look at the public reports that are coming out about the number of amicus appointments, you will see an upward trend, and so I think that's a good thing. My personal inclination would be to try to ensure that the amicus is involved as much as possible, including in every matter where you can be confident that there's going to be a significant programmatic decision made. One example, and this is purely in my individual capacity that I've cited in the past, is the annual certification proceedings that take place under Section 702. That's different from a Title I FISA wiretap where you're looking at one guy and what that person may have done. This is a programmatic judgment about the safeguards in place for a large-scale collection program. And in my view, that's exactly the type of situation where you should, by definition, always have the participation of the amicus.
Would you consider going so far as to just say, let's have amicus participation in every case?
I wouldn't, Senator, respectfully. Most FISA court proceedings are analogous to warrant proceedings that take place on an ex parte basis in normal courts around the country. And judges, federal district court judges, are used to hearing those things and making those decisions in an ex parte matter, and I think that makes sense for various reasons.
I suppose some of the concern underlying what you're describing could be addressed by providing a carve-out for cases involving an emergency, but I suppose that's a different question. Ms. Goitein, I have some questions for you, but before we get to those, I sensed a few minutes ago that you wanted to respond to one of the arguments that was being made with regard to the lone wolf provision and the probable cause showing. Do you want to get to that?
Thank you. Yes, I just wanted to make sure that we understood that we were, in fact, talking about a probable cause standard. It's not lower than probable cause, and that we were talking about probable cause that a person is preparing for or engaged in acts of international terrorism. And if you look up the definition of international terrorism, it's pretty much what you might think. So the notion that somehow that would not be enough to get a criminal warrant, first of all, doesn't make a lot of sense on its face, and second of all, isn't borne out by the record. Right. It's not that people haven't, it's not that the government hasn't been getting the information it needs, it's that it's been getting that information through other means because the lone wolf provision isn't necessary.
Right, and it's not necessary if it is at least as difficult as, but without the precedential track record of other mechanisms already available. Is that what you're saying? So why have it on the books if it's never used, and it's not likely going to be used because it doesn't really plow any new ground?
It's never been used, and it removes this principle of connection to a foreign power or agent of a foreign power that is the unifying principle behind when we use the FISA process as opposed to some other process. So it sort of opens the door to sort of gradually degrading the rights that are available to non-U.S. persons who are lawfully inside the United States.
So you're creating a danger that's unnecessary given that it hasn't been used.
Exactly.
And how do you think Carpenter applies in the FISA collection process?
Sure. So the court in Carpenter essentially held that there are certain types of information that are so sensitive, so inherently sensitive in what they reveal about a person's life, that the mere fact that they're held by a third party does not eviscerate the person's Fourth Amendment interest in that information. And in that case, it was several months' worth of cell phone location data. Now, the court was very careful to say that it was limiting itself to the facts of the case. It said that this would not apply to, quote, other techniques that are used in the foreign intelligence and national security areas. But if, in fact, Section 215 is being used to collect cell site location information, that is not another technique, that is the same technique, so I think Carpenter would apply there. And while the court is not responsible for applying its general principles to cases that aren't in front of it, Congress can't avoid that, right? And the government can't avoid that. You need to figure out how, before reauthorizing this legislation, how you think Carpenter would apply to some of the other technologies and some of the other information that we know that the government is almost certainly obtaining through Section 215 orders. There are certainly other types of information, other ways of obtaining geolocation data, or other types of information that are similarly sensitive in what they reveal about a person's life, where the logic of Carpenter would absolutely hold. So I think that is something that Congress should be looking at now when it reauthorizes Section 215, in large part because the government has failed to do so. In March, we got answers from the Director of National Intelligence saying there had been absolutely no intelligence community-wide guidance on how to implement Carpenter, and then congressional requests for additional information since then have gone unanswered.
In other words, there's nothing magical or talismanic about uttering the words national security that creates some sort of loophole within the Fourth Amendment. You have things that the government may do, and you have things the government may not do. But that doesn't turn on whether you utter the words national security or put it in the context of a foreign intelligence investigation.
That's certainly correct with respect to domestic national security, and for foreign intelligence, Congress has in the past made the decision that the protection of a warrant or something like a warrant, a FISA court order, should apply when extremely sensitive information is at stake.
Thank you.
Thank you. This